Okay, friends, let's change things up a little bit. Let's go down to the great state of Georgia, Fulton County. This is Judge Rachel Krause. Let's see what she's got going on.
He'll be here by me, and just the judge can see Ms. Potter behind us there.
Okay.
Okay. So, Mr. Burke, can you hear me and see me okay?
Yes, ma'am.
Okay. So, Madam Court Reporter, this is going to be a plea hearing in the matter of Maurice Burke, case number 25 SC 002-106. I'll note for the record that Mr. Burke and his attorney, Mr. Murphy, are both present in the courtroom, along with the counsel for the district attorney's office for the state, Ms. Potter. I am attending this hearing remotely. I appreciate your accommodation. I was called away on an emergency matter related to a medical issue with one of my kids, and so I appreciate your accommodating me being remote today. I'll also note for the record that the individual who might need to speak with Mr. Burke regarding probation matters and reporting instructions, including registry issues, is also attending this hearing by video. Her name is Teresa Carty. Mr. Burke, here's what's going to happen in the next few minutes. In a moment, I'm going to ask the state to provide me with either an agreement that the parties that there is a sufficient factual basis for whatever the agreed reduced charges are, or some factual basis from the state. Assuming that there is a factual basis, either by agreement or otherwise, then I'm going to swear you in, and Ms. Potter is going to ask you a series of questions to make sure you understand what rights you have and what rights you are giving up by entering this plea. Do you understand that, Mr. Burke?
Yes, ma'am.
Okay. Now, during this process, if you don't understand something or if you need clarification, you're free to ask Ms. Potter to clarify. You're free to ask me to explain, or you're free to step back and speak privately with your attorney. Do you understand that, sir?
Yes, ma'am.
Okay. Ms. Potter, let's start with this. Can you tell me I understand this is a non-negotiated plea in the sense that the parties have not come to a full resolution of the amount of time that they would present to the court, but that some aspects of the plea have been negotiated. Can you tell me what those aspects are?
Yes, Judge. Both counts are going to be modified to sexual battery. CGA 16-6-22.1. They both carry a 1 to 5 year sentence. And so we negotiated count 1, 5 to serve 3 years, balance on probation. Count 2, 5 years probation consecutive, which gives us a total of 10 to serve 3 years, with the remaining 7 on probation. Register as a sex offender upon release, get a psychosexual, follow any recommended counseling, and no contact with the victim, Ms. Perkins. And correct me if I'm wrong, Mr. Murphy.
Yes, as to everything, except there wasn't an agreement as to the time to serve. But yes, we agreed to the registry, which I think is required, the psychosexual evaluation, and the any recommended treatment and no contact.
Okay, thank you. Mr. Murphy, for purposes of resolving the case today, is Mr. Burke willing to stipulate that there is a factual basis for the 2 reduced charges of sexual battery in counts 1 and 2?
We do stipulate to a factual basis, Your Honor.
Okay, thank you. Mr. Burke, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you, sir. You may lower your hand. Ms. Potter, if you go ahead with the colloquy, please.
Yes, Judge, thank you. Mr. Burke, I know I'm behind you, but you can see me on the screen. Can you see me kind of?
Yes.
Is that okay? Okay. At this time, are you taking under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you haven't taken today?
No.
Can you hear him okay? How old are you?
22.
And how far have you gone in school?
12.
So you graduated?
No.
No. Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand in indictment 25 SC 002-106? The state is modifying the 2 charges to sexual battery, which is OCGA 16-6-22.1.
Yes.
Okay. And do you understand those are both felonies, given the fact that the victim was under 16 at the time?
Yes, ma'am.
Okay. Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Okay. Have you gone over all of your rights with your attorney, Mr. Murphy?
Yes, ma'am.
Have you had enough time to speak with Mr. Murphy about all the facts and circumstances known to you regarding the charges in this case?
Yes, ma'am.
Okay, including any and all potential defenses?
Yes, ma'am.
And do you need any more time to discuss the case with him?
No, ma'am.
Okay. And Mr. Murphy, do you waive formal reading of the indictment?
So waived.
Okay, and do you waive any and all defects?
So waived.
Okay. And the state is not aware of any outstanding warrants on these on this indictment or these charges. Are you, Mr. Murphy?
I'm not aware of any, no.
Okay. Judge, will he be able to withdraw his plea?
No, because the matter is set on a trial calendar, I believe.
Understood. Okay. So, Mr. Burke, this is what's called a non-negotiated plea or a blind plea, which means the state's going to give their recommendation to the court and your attorney's going to give his recommendation to the court. And then the court is going to actually decide on the final sentence. Since it's non-negotiated and we're at the trial calendar, whatever Judge Krause sentences you to, you cannot withdraw it. As opposed to a negotiated plea, if you didn't like or want to go forward with the sentence after she announced the sentence, then you'd be able to withdraw it. But you cannot withdraw it here. Do you understand that?
Yes, ma'am.
Do you understand that this is a guilty plea which will permanently be recorded on your criminal history?
Yes, ma'am.
Okay. And do you understand too that the court can sentence you to a higher sentence than what the state has recommended?
Yes, ma'am.
Okay. These two charges amount to a total of 10 years. So you're looking at a maximum of 10 years in custody. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or violate any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Okay. And do you understand you're not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Okay. Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up certain rights, and I'll list those out to you. That's the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. So essentially, by entering this guilty plea, you're giving up or you're waiving all those rights I just listed. Do you understand that?
Yes, ma'am.
Okay. Does anyone force, threaten, or promise you anything to get you to enter this guilty plea?
No, ma'am.
Okay. And is it your decision to plead guilty because you are in fact guilty?
Yes, ma'am.
So how do you, an indictment 25 SC 002106, how do you plead to the modified charge of count 1 sexual battery?
That's, you have to just announce that you.
How do you
Oh,
plead?
guilty.
And count 2 sexual battery 16622.1 as well. How do you plead to that count?
Guilty.
Okay. This guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you have only a limited right to appeal this guilty plea conviction? For these felonies, you have 4 years from today, you've got 30 days from today to file a direct appeal, and you have 4 years from today for this felony charge to file what's called a habeas corpus petition, and that challenges the voluntariness or constitutionality of what's going on here today. So those are 2 time limits that you must be aware of. Do you understand?
Yes, ma'am.
Okay. Thank you, Mr. Burke. That's all I need from you. Judge, as far as I am aware, Mr. Burke does not have a, the only thing I would like to add is, given the fact that the DNA results are still pending, and we were on a trial calendar, the court or the state has modified or reduced this to sexual battery. The victim is okay with this sentence, as she was ready to testify, and she was 13 years old at this time. Given all of those facts, Judge, we ask that you accept the 10 to serve 3 recommendation from the court. And at the time the court feels it's convenient, the victim, I don't believe the victim is on, but my advocate, Ms. Kristen Clark, is on, and she has a impact statement that the victim wrote.
Okay, and now is the appropriate time for me to hear that victim witness impact statement. Ms. Clark, are you there?
Yes, Judge. My camera is going in and out, so I'm not going to turn it
Don't
on.
worry about it. If
Okay.
you'll do me a favor and just start by stating and spelling your name and role, and then the name of the victim, and then read me her statement.
I am the victim witness advocate. My name is spelled CHRISTEN, last name CLARKE. And I am reading the statement on behalf of Shania Jenkins. It's spelled SHANIYA Jenkins, JEKINS. And it states, Dear Judge, I was 13 in 2023. I was taken advantage of. I was touched inappropriately, and my body was touched in ways that I can't talk about because it was so bad. Every waking moment of my life, I think someone is out to get me. The defendant has caused me so much pain. I have issues with sleep because every time I close my eyes, I can envision what the defendant did to me. The defendant placed his private part somewhere he knew it did not belong. I am still traumatized physically and emotionally. The defendant took away my childhood and innocence. I always blame myself for what happened. I'm always angry and I don't feel safe around men. I hope one day he will realize the pain that he has caused me and my mom. I remember having nightmares and crying every day. I want the defendant to know I have very bad PTSD and really bad depression because of what happened to me. I'm putting my life back together slowly, and Judge, I'm doing better in school now. I pray I'm the last victim, and I hope the defendant does not ever get to do this to any child ever again. Thank you, Judge. Sincerely, Shania Jenkins.
Thank you, Ms. Clark. Mr. Murphy?
Thank you, Your Honor. Your Honor, I'll first say there was a lot of negotiation that went on with this, and I appreciate the time and effort of Ms. Potter in taking a very hard look at this case and agreeing to reduce it to the sexual battery count. I understand there was the DNA issue, but there were also some significant mitigating factors involved. Mr. Burks had just met the victim the day before. We know that it is not a defense, but he was given a different age by her. And then she came to his home with some friends the next day. So he takes full responsibility for his actions, but I do want the court to know that there were some significant mitigating factors that also go in to making sexual battery seem a much more appropriate charge that fits the facts of the case, fits the circumstances that were there, and fits the investigation that was done after the fact. Mr. Burks is 22 years old as he stands here before you, Your Honor. He is a lifetime resident of the Atlanta area. He went to North Clayton High School. He did not finish his senior year, but he is currently enrolled in a GED program as he stands here before you today. He also works full-time for Amazon in addition to that. He has never been in trouble before, Judge. He doesn't have a criminal history. So this was something that, was out of the ordinary for him. And I think he would tell you he certainly did not want to harm anyone and is here with a significant amount of remorse and contrition as he stands here before Your Honor. When I first began negotiating with Ms. Potter, I did from the outset ask that she reduce this to sexual battery, and I did with a very straight face go to her and tell her that I thought probation was appropriate for the case for a negotiated plea. She obviously objected to that, and we're here with an understanding of what we're doing, Your Honor, but I do want the court to know why I went to her with that, and it was because of the issues with the underlying case, the facts of the case, the lack of a criminal history by Mr. Burke and the significant support in the community and family that he has. I don't know if you can see the people in the courtroom, Your Honor, but I know you've seen in the past the significant number of people that come to court with Mr. Burks every time we come before Your Honor. His mom and dad are both here. His brother's here. His brother's girlfriend's here. His sister's here. His partner is here. Judge, she is actually going to be giving birth to a child expected on August 11th of this year, Your Honor. And all of those people are here to show support for Maurice because they love Maurice. And, despite knowing these allegations against him, they stand by him. They know everything about this. They are all fully apprised of the case, know everything about it, and make sure that they are here to show up and support him at every possible opportunity to do so. Based on that, Your Honor, we are tendering the guilty plea. We do not have any objection to the full sentence being 10 years. We do not agree with the 3 years being appropriate in the case, Your Honor. We think given all the circumstances that was significantly more. I will say after we initially went to probation, Ms. Potter had a higher offer than she has come to the court with today. We did come forward and ask to do a negotiated plea at 10-1. We were not able to get there today. So we are asking the court for that. That is the sentence we are asking the court to pronounce. We do not have any objection whatsoever to the registry. I think that is required given the subsection that the plea is under on the sexual battery statute. We have no objection to a psychosexual evaluation. We have no objection to any treatment that is recommended that he will undergo diligently and be ready to do. Your Honor, we would ask if the court would consider sentencing him under the First Offender Act, given his lack of a criminal history. He does not have any prior sexual battery charges. And for purposes of the First Offender Act, a second sexual battery conviction would prohibit him. But given that he has no criminal history, he would be eligible for that. We have talked about the carrot and the stick of that at length, and he understands that and has absolutely no intention of ever being before Your Honor or any other judge ever again once he puts this situation behind him. So that is what we would ask, Your Honor, and Mr. Burke would also like to address the court as well.
Okay, before I hear from Mr. Burke, Ms. Potter, does the state have any objection to the court's consideration of that first offender?
Yes, Judge, we would object. And that is not something we even talked about during any of our negotiations.
Okay. Mr. Burke?
Your Honor, I thank you for allowing me to speak. I take responsibility placing myself in a situation I should have avoided. And I understand how serious this has been. This is my first offense, and this experience has been a wake-up call that has caused me to reflect deeply on my decisions. Since then, I have been focused on doing better. I am working a full-time job, enrolled in school, raising a 1-year-old, and preparing for another child on the way. I respectfully ask the courts to consider an alternative sentence to allow me to continue this progress while still held accountable. Thank you for your time, Your Honor.
Thank you, Mr. Burke.
Judge,
Mr. Burke, I just have, yes, ma'am, Ms. Potter?
Sexual battery is not eligible for first offender either, under 4260.
That's one of the reasons I asked you, because I wasn't sure, but I thought that perhaps it was not. So thank you for clarifying that, Ms. Potter.
Yes, Judge.
Mr. Burke, I have a few just follow-up questions for you, and it's mostly just to spot check what you've already been asked by the state. But you understand that you have a right to plead not guilty to these charges, correct, sir?
Yes, ma'am.
And do you understand that you have a right, if you plead not guilty, to have a trial with a jury?
Yes, ma'am.
And do you understand, sir, that at a trial, you would be entitled to be represented by an attorney, including one at no expense if you couldn't afford one?
Yes, ma'am.
And do you understand that at a trial, your attorney would be allowed to ask questions and to challenge the evidence that the state offered?
Yes, ma'am.
And do you understand that at a trial, you would not be required to testify as you're doing now?
Yes, ma'am.
And you understand, Mr. Burke, those questions that I've just asked you and most of the questions that Ms. Potter has asked you are about important rights that you have that you are giving up by entering this plea.
Yes, ma'am.
Thank you, Mr. Burke. So it appears to me that Mr. Burke has an understanding of what his rights are and that it is his intention to waive those rights and enter a plea. And so I will accept his plea as knowing, voluntary, and intelligent. And the decision-making process for how to sentence in a case like this is not an easy one. I suspect it's the same reason that the state and the defense weren't able to come to an agreement, because the nature of the offense to which you have admitted is so concerning and bothersome and problematic in our community. But I'm also faced with a young person who's not previously had legal difficulties, who has taken responsibility for those actions, and who has offered some evidence of mitigation, the extent to which, whether it's legally valid mitigation or not, but certainly factors that would have been a matter for consideration if the case had gone to trial. And so ultimately, the real question, although Ms. Potter mentioned to you that the court does have the authority, and you indicated you understood that, to sentence you anything up to the maximum that's allowed by law, which would be 10 years in custody. The court isn't going to do that. Really, the choice the court is making is between the 1 year that your attorney is seeking and the 3 years that the state is seeking. And under the circumstances of the case, given the lack of criminal history and the responsibility, the fact that Mr. Burke is here and is taking responsibility for his actions, I think I am inclined to err on the slightly lower side of that. And so what I'm going to do is sentence Mr. Burke on count 1 to the reduced charge of sexual battery under OCGA 16-6-22.1 to 5 years to serve 18 months in custody and the balance to be served on probation. As to count 2, on the reduced charge of sexual battery in case number, as in OCGA, reduced charge of sexual battery in OCGA 16-6-22.1, I'm going to sentence Mr. Burke to 5 years of probation. Count 2 will be served consecutively to the sentence in count 1. In count 1, after the 18 months, the balance of that will be on probation. As we have already discussed, Mr. Burke is required to register as a sex offender, and he will be required to undergo a psychosexual evaluation and comply with any treatment recommendations that arise from that. And I also require that he have no contact with the victim. Mr. Burke, I do want to caution you and your family who've been so supportive of you that sometimes it happens that family members and friends have contact with the victim thinking they're helping their family member. They're not. I'm just going to remind you that when I say no contact, that means no direct contact, no indirect contact, no social media, and no one else can contact that person on your behalf. All of that would potentially be a violation of your probation. As was discussed a moment ago, I don't know that I would be inclined to allow for first offender treatment, but I don't believe that I understand why Mr. Burke would seek that accommodation and that treatment. But I think Ms. Potter is correct that it is not allowed for these types of offenses. And so I don't know that the court needs to rule on that from a discretionary perspective because I don't think it's legally allowed. Excuse me. Beyond that, Ms. Carty had brought to the court's attention that there is some paperwork that Mr. Burke will have to sign, indicating some of the requirements of his registry. Ms. Carty, I have the paperwork, I'm looking for it, and this is something that I want to make sure we do correctly. I know Mr. Burke has to sign off on it, but there are a long list of potential special conditions that the court has to either require or not require. Is that correct?
Yes, Your Honor.
Okay. And so the form that I'm looking at for special conditions of probation, Mr. Murphy and Ms. Potter, had the two of you discussed anything regarding the nature and scope of these special conditions. I mean, some of them, I understand the original charge was child molestation. The victim in this case is case was 13. Some of them apply more directly. Some of them might be a little less applicable. Had you had a chance to discuss those at all, Mr. Murphy, Ms. Potter?
We have not discussed those, Your Honor.
Okay.
I think the only one I would have a significant concern with is his own being able to reside with his own children.
Yeah, and I would agree with you and would strike through that requirement in subsection 2 that Mr. Burke would be allowed to reside with his own children, but not with any other children under the age of 18. However, note that that application does allow approval in advance. And so, for example, if Mr. Burke were to live with family members and had a younger sibling, or if he were to live with a partner who had a child that was not his, that can all be approved, and the court doesn't necessarily have a concern with it. It just would need to be approved. The only thing I would be striking through is any limitation on Mr. Burke's ability to live with his own children. Beyond that, I feel like the parties could probably negotiate. Obviously, he wouldn't be allowed to have any contact with the victim. That's a special condition. And I feel like the parties might be able to discuss and agree on the application or lack of application of these other aspects. For example, I don't think it's necessary for Mr. Burke to keep a driving log. But I don't think anybody should pick up hitchhikers or hitchhike, which I think is always funny to me that that one's included. But I would.
I don't think to the polygraph, you can take that off.
Okay.
No driving log, no hitchhiking, no the 900 numbers in post office.
Right.
And then everything else the state would like to apply.
Okay, so here's what I'm gonna read off, Mr. Murphy, if you're aware, and tell you what I would be inclined to apply, and let me know if you have any concerns. Count 1 is contact with minors, and that would be applicable. It's sort of the main limitation. Count 2, we've already addressed, which is he would be limited from residing with a minor other than his own children. But again, that can be approved in writing if it's other children, as in the circumstances I mentioned. The residence change, and that would be applicable. The victim contact would be applicable. I would not prohibit Mr. Burke's employment. I would not apply item number 5. I would not apply item number 6, item number 7, item number 9, item number 10, item number 12, item number 18, or item number 19. The rest of them would be applicable, Mr. Murphy.
That's agreeable, Your Honor.
Okay. Ms. Carty, did you get those?
Yes, Your Honor.
Okay, thank you. I believe that would conclude this matter other than reporting instructions. And of course, we need to have these papers finalized and signed by Mr. Burke. Logistically, I'm sorry, it's going to be a little bit of a headache because I'm not physically there to have it printed for you. Are the parties able today, while you're in the courthouse, to secure the printout of those documents and Mr. Burke's signature on them so that they can be provided to the court, or we can provide them to Ms. Carty so they can be finalized? Is that something y'all can accomplish today, Mr. Murphy? I'm sorry, yes, Mr. Murphy and Ms. Potter?
Yes, Judge. If Mr. Murphy just hangs around for a couple of minutes, I'll get them printed and be right back.
Okay, excellent. And then the other thing is, in order to finalize the plea, you would need to sign the indictment indicating that there's been a plea entered. And Mr. Burke, since you've not been provided with a copy of the indictment, you have previously reviewed the indictment with your lawyer. But in order to finalize the plea today, do I have your permission to sign your name to the indictment indicating that you have entered a plea today to the reduced charges of sexual battery?
Yes.
Thank you. Mr. Murphy, may I sign your name?
You may, Your Honor.
Ms. Potter, may I sign your name?
Yes, Your Honor.
Okay. Ms. Sherman, did you have an issue or question?
Judge, I did. My apologies. Since all parties are there, Ms. Potter, is it possible for her to print out the indictment? If not, and they can just sign it since all parties are there. And once you scan back the conditions, they can be all scanned to me.
Okay.
If
I-
possible, Your Honor.
Yeah, I mean, if Ms. Potter, if you're printing something, if you could print the indictment and have everybody sign it, that would be great. If not, the record reflects that the court's authorized to sign that indictment on everyone's behalf. Anything else from the state, Ms. Potter?
No, Judge, just that we do, I guess, anticipate Mr. Burke going into custody today.
I'm aware of that. Mr. Burke and Mr. Murphy, we had previously discussed, Mr. Burke understands that he's going to go into custody today. If the deputy can go ahead and start the beginning of that process so that we can get you, get that process started, and then we'll get your signatures. And Mr. Murphy, does Mr. Burke have any time in custody previously? I mean, I'm happy, he would be entitled to credit for that time if he does.
It was a very short amount of time, Your Honor. He was able to almost immediately bond out.
Okay.
I can probably tell you the exact, was it a day?
Like 5 days.
He believes it was 5 days, Your Honor. I'm sorry, I'm pulling it up now.
Well, our record will reflect what time he spent in custody, and he will be given credit for that time. I just wanted to put that on the record. Anything else for the defense, Mr. Murphy?
No, Your Honor.
Okay. Mr. Burke, when you are released from custody, where will you reside? What county?
Fulton.
Ms. Carty?
Yes, Mr. Burke, 48 hours after release, you're going to report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. I will send the reporting instructions to your attorney and he could forward that to your family members.
Thank you.
Thank you all. That concludes this matter. And deputies, if you'll take Mr. Burke into custody, as I said, they'll be back. Mr. Murphy will be back in a moment to have signatures put on the appropriate documentation.
But I'm gonna go to the Krause thing for a minute. So this dude most definitely had his issues. So we had the involvement with the, at the time, 13-year-old, and this was 2023, if I recall. So 2-3 years ago. So when he was 22 now, so he would have been 19 or 20 at the time himself. Still, he's an adult. That's a child. Not acceptable. But he's since got a 1-year-old and another one on the way. So I wouldn't exactly call this guy captain responsible, that's for sure. At 22, that's just too much. Now, I'm not necessarily a guy who thinks we should all be waiting to be in our 40s to have children. I think that's probably the wrong call, too, to be honest with you. Having children is a young person's game. However, you have to be established and responsible, and he's clearly not. So he doesn't care what he does and who he does it with. So, it's evident to me that the guy has some serious issues. In the same respect, the court and the prosecution seemed to acknowledge that there were some issues with that case. They did not, for whatever reason, have DNA on it. I didn't completely follow what was going on there, but it sounds like there was some trouble getting the DNA results. So a lot of your physical evidence is missing. There was also apparently some mitigating factors regarding the knowledge of the young lady's age. And you can definitely make an argument that that's his problem. And I don't necessarily disagree with you. In the same respect, it's getting harder and harder and harder to tell the age of some of these young people, both boys and girls. And it's not It's not that hard anymore for you to mistake somebody for being older than what they are. Now, again, that doesn't mitigate the responsibility or eliminate the responsibility. It's still on him. And I don't disagree with that. But I suppose that these couple of things, I think the prosecution and the court have to look at it and go, yes, there's holes in this. There's a problem with this. So that has to be factored in. Like it or not, it just has to be factored in. So they couldn't reach an agreement. They left it open to the judge, but it had a cap of 10. He walks away with 18 months to serve. And again, if I heard it right, that the second count was to run consecutive, then that would be 8.5 years of probation. So I don't think he walked away with nothing. From what the prosecution said, the victim signed off on it. So there's that. And again, we've talked about it statistically. This young man is not going to make it. Those 10 years. It won't happen. At 22, I need to find those stats. I don't know where I left them on my computer, but I need to find them so I have them handy because we seem to be referencing them a lot. But it's like a 90% failure rate at that age with that length of a probation. So, and his behavior would indicate that he will definitely fail, because what inside of him seems to take responsibility for anything other than he did plead guilty? So he did take responsibility there, probably to avoid the thing going to trial and being even worse. But regardless of motivation, he did stand up and plead guilty. Didn't no contest it or anything like that. So I don't know. I think in this instance, justice was probably done about as good as it was going to get done. Because if the prosecution was missing the DNA evidence, if they even acknowledged there was some potential mitigating factors regarding knowledge of age, then if that thing had gone to trial, there's a good chance that there would have been a not guilty. So I think you have to weigh those things, and he probably got about as good of a deal as he was going to get, and quite honestly, the prosecution probably got about the best they were going to get out of it too. Now, this is just based on us watching and hearing, though obviously we don't have all of the facts behind the case, but that's my feelings on it. If you have different feelings, you can let me know, but I think if we look at it dispassionately, I don't know if there would have been a better outcome for either side, for him or for the victim and the prosecution, just based on what they were saying that they had issues with. Could be wrong. Hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.